Ladies and gentlemen, there are three things that I need to talk about this afternoon. There's no magic bullet, there's no magic pill, there's no silver bullet. There is no, one shot fits all. It just doesn't exist. If you have debts, if you have, pay attention, mortgage foreclosure issues, there is no one mechanism. Why? Because the courts have systematically, throughout the years, been killing all of the original solutions and options and remedies. So, what we have to do is we now have to beat them at their stupid own game. Since they've come up with all of these little presumptive responses, now you have to kill the presumptions. So, I just did a video explaining the whole promissory note thing and how your promissory note is not what the courts are saying it is. And I've proven it there in that video. Now, I'm putting together a document that you guys will be able to use to bring up the same arguments. But you're going to have to watch the video so you'll know how to overcome their presumptions, because that 2 hour and 36-minute long video, the GPT model is giving you the presumptions of the court. And you'll see how I overcome each and every one of their presumptions, not with my own reasoning, not with my own logic, but with the law. So that's the first thing that I've talked about, and I'm going to let that be. The second thing is a young man who is a YouTuber. He's a YouTube content creator. He suffered a stroke because he's been trying to help people, and he's been stressed and worried about things, and they've been coming at him because he's been going at them. And this ain't easy, everyone. Trying to help everyone, I'm not trying to take your money. I don't want your money. That's why I give you the information for free. Your job is to do the research. He's the same way. Well, he asked me, he says, are the courts corrupt? It's not the courts that's corrupt, it's the system that's been corrupted. The courts are not corrupt. If you hit them in the head the right way, they'll do what they're supposed to do. But you have to give them something. So most of you are creating your own documents and you're bringing up these arguments you're hearing from YouTube. Stop that. Because when you bring up the argument, you haven't done the research. You're just bringing up an argument. And so they use what you're saying in court against you. So please stop that. Now the third thing, they're saying they don't want you using AI. They don't want you using templates. That's a lie. You can use AI and you can use templates. They use templates and they use AI. For instance, let's show y'all something. We're going to take a trip. I'm working on an application. So we're gonna leave the application alone because we've been working on that for a minute. But we're going to take a trip. We can go to Chat GPT. Now, I'm going to go to one of my GPTs because if I go to it, it's just going to put me through the round and round and round we go. And let's go to the money creator, because we're going to be talking about money in a second. So pay attention to this. Wake up. Have you heard of a word processor? Question mark. Just yes or no. No explanation. A word processor is basically a computer program that takes your words and puts it in a different format, correct? Is there a law against using a word processor to produce documents before the court? Yes or no? I said yes or no. What if I used a form template with the court to communicate with the court my presumptions and or responses and or complaints? Comma, is there a law against that? Comma, yes or no? Or no? Why then do the courts state that individuals' documents are from a template? Question mark. If there's no law against it, then what gives the court the right to raise such a stupid statement? Question mark. Stupid. Stupid. You're stupid. Stop listening. Ladies and gentlemen, the voice recognition software has been programmed because it doesn't want me disrespecting the court. So when I said such a stupid statement, it took away the word stupid. It is a stupid statement if there's no law. There's no law against using templates. This kind of statement typically serves three unofficial purposes. Again, unofficial. So the court can dismiss your junk, but it's illegal. You are lawfully allowed to use whatever template you want, as long as the template has facts and conclusions of law and has a foundational standing. We have one young lady, the court, watch this. I have a young lady who proceeded to file a document in court that was AI generated, but she edited it to fit her circumstances and added her statements to the document. The court proceeded to say that it was full of hallucinations. First of all, a document that is basically a response to someone's document they placed on a record and is based on facts and conclusions of law and is titled an affidavit cannot be based on a hallucination, especially when it was edited by the person producing it to make sure it conformed to their thoughts and their understanding. So the court saying it was hallucination was a violation of due process. Then we have the issue that the court stated that it was from a form template. Now that is a violation of due process rights because the courts are to liberally construe pro se documents. The courts have said things like the documents are gobbledygook or nonsensical or gibberish. Using words like this to undermine an individual's filing, when an individual uses AI to assist in writing and producing something to the court, now they're saying hallucination or form template or they use AI. Every single time they're looking for an excuse to ignore pro se proceedings. Ladies and gentlemen, what happens is if it ain't one thing, it's another. They're looking for a reason, always looking for a reason. That gobbledygook stupidity, that nonsensical stupidity, this is the junk they say. These are just words. Now, let's clarify and ground this due process, equal protection, and binding precedent. No law prohibits using templates or AI. There is no law that says that you cannot use AI, so y'all keep using AI. It's the same thing as using a word processor. Now, due process and liberal construction of pro se filings. Everybody knows that a pro se filing must be liberally construed. Now, a hallucination asserts facts based on personal knowledge, contains conclusions of law based on cited authority, and is signed and declared under penalty of perjury, cannot be dismissed as hallucination without evidentiary contradictions because it must be rebutted point by point. A sworn affidavit is presumably valid until contested with clear proof. That's always going to be the case. The courts use derogatory language, gibberish, nonsensical, blah blah gobbledygook. They risk violating the canon, the code for the United States judges, which requires judges to be patient, dignified, and courteous. You see, they can't criticize you. They can't put you down. They can't personally attack you. They can't call you a sovereign citizen. It's against the law. Not just their canons, but it's against the law. See, they have to be impartial. They cannot use personal attacks. Now, would you like to analyze and convert into a motion declaration memorandum? In this particular situation, the individual is an adult of greater than 40 years, and the court has tried to belittle her and berate her at every single turn within the courtroom. She's even tried to show off. She scheduled a hearing last Wednesday, and at that hearing is when she made all of these comments about hallucinations and gobbledygook and nonsensical. And then she tells the individual that she's going to take it under consideration, the affidavit. And the judge cannot rebut an affidavit. Even if they wanted to rebut an affidavit, they do not have the jurisdictional standing to rebut an affidavit. Only a opposing party can rebut an affidavit. Other than that, the affidavit stands true. There is no jurisdiction for a court to intercede and rebut the affidavit on behalf of the opposing party. But the judicial officer said, we will meet back here at 2 o'clock. When the individual showed back up at 2 o'clock, the court was surprised, said it did not and was not aware that the individual would be coming back. That hearing was recorded, and the stenographer was there, which means this judge individually, in her individual capacity, lied on the public record, because when a judge sits on the bench, she is sitting under oath of office, and she has taken an oath to uphold the Constitution, which prohibits her from lying or placing misleading information on the public record. Placing knowing and false and misleading information on the public record when an individual knows the information to be false is a felony in the United States. That's the petition I want you to put together for me. And I need you to back it with facts and conclusions of the law. And I do not need you to water it down or put in language that is less forceful. Ladies and gentlemen, that judge lied on the record. She is under oath of office. She did it on purpose. Now, I'm surprised it did this. Normally, it will take all of my writings and make it blank. Like I said, I just wanted to talk about 3 things. This was the final one. You're requesting a petition of judicial misconduct, felony misrepresentation. No, I did not say judicial misconduct. When a judge commits misconduct, that is a reversible error. But when a judge violates the law and violates due process of law, that is deprivation of rights while acting under color and authority of law. And under the Civil Rights Act of 1866, and not its codification, it is a crime. Although a crime carrying 6 months to a year, it is still a crime. It is a felony under law to place false and misleading information on the record. So no, this is not a misconduct issue. Misconduct goes to the Board of Judicial Conduct or the Board of Misconduct, and nobody wants to file a complaint with them because they do not do anything, because they are just an administrative agency. Now you see how it wanted me to give it some clarification and then producing the document. So now we're going to take care of it this way. You're asserting criminal deprivation of rights under color of law, not judicial misconduct. You're invoking the Civil Rights Act of 1866, constitutional right to due process, and the principles that placing knowing and false misleading information on a public record while acting under oath of office constitutes a felony level criminal conduct, not mere administrative error. And you are further affirmed that the judge acted in her individual capacity under color of law, and act of rebutting a sworn affidavit without standing is an unlawful interference in favor of a party. And select your preferred legal venue. Give me 1 second. Y'all, hold on 1 second. I put in a bankruptcy. Stop listening. I put in a bankruptcy document, and I told it don't use the petitioner's name. Now, if it uses the petitioner's name, I'm just going to have to redo the video all over again. I just need it to produce the document. So it's producing the document. And I told it where it comes for the bankruptcy court and all of that, she's just going to enter the case number. This is an actual petition. Okay? And I will go over this. No, that's not a petition. No lawful petition is ever done that way, even by a pro se individual. I have been doing law for 42 years, and I've never seen any junk like that. Who told you to use language that was less forceful and not as potent as the original? No, that will not do. And you already have the fact that it's bankruptcy, you already have the state. So add the bankruptcy title and the state. You can omit the case number. The reason why I called it on it, you see how they list the paragraphs 8, 9, all of that stuff? It did that on purpose, and I ain't got time for that stupidity. It's too long. It's been such a long time. Okay, I have to do that because you saw it gave me a blank screen. So this is it right now. Yeah, and it did that right there. And okay, it's still doing the numbering the paragraphs. That's not how. Give me a second. Give me a second, y'all. Where are my case citations? Sorry. Where are my case citations? Where are my case citations? There should be at least 15 case citations supporting the points in this petition. And who told you to list my paragraphs the way you've done it? No one lists paragraphs in such a manner. This is not a professional or legal document that is required under law to be submitted to anyone. How dare you give me this piece of garbage? I want a professionally done document. Because I said pro se, it decided to do this junk. And we can't have that. We got to have something better. So it's going to take the template and redo it. And as long as you have it do it in a dialog box, this is what happens when it's a dialog box. It doesn't have to redo the document. Okay? Unrebutted affidavit is considered truth in law and stands as judgment. It doesn't actually stand as judgment. It stands as truth. Okay? Stands as fact. Doesn't stand as judgment. It did that, and I'm going to correct that. Give me 1 second. Sorry, that's not detailed enough. You didn't put in judicial ethics information. You also did not put in the fact that a judge who exceeds their jurisdiction acts in clear absence of all jurisdiction as determined in stump. I told you I've been doing this for greater than 42 years. Oh, also, you when you did this particular petition, there were some things that you stated. You said that a unrebutted affidavit is considered truth in law and stands as judgment. There is no court case citation or maxim of law that says it stands as judgment, you stupid idiot. Why would you add that stupid discrediting language? I told you not to ad lib or add your own opinion or do any of that stupid stuff. You need to stop with that ignorance. Putting that sovereign citizen language in my document. Stop doing that stupidity. Sorry. This is why many of you are having the problems you are with the court ignoring your documents. Is because if you use AI, it's going to add that sovereign citizen junk that it ain't supposed to be adding. The court may not sua spontaneity. Anyway, spontane, refute such affidavit testimony. Doing so constitute improper judicial intervention. Now, at a hearing, they're going to insert the date, the judge, blah, 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 and the language exceeds the bounds of impartial judicial conduct and breaches the judicial ethic, blah, blah, blah. Now, give me a second. Be right back. Okay, what I just told it is that companies have been using computer technology. See, AI does not mean artificial intelligence. Yes, it stands for artificial intelligence, but it doesn't mean artificial intelligence. AI technology just is large language models. We don't have access to AGI. We don't have access to artificial intelligence. So, use of AI, people have been using AI, pay attention, since the 80s when they first came up with word processors. Why? Because all a word processor does is anticipate the word that's supposed to be there, commas, punctuations, and other things. So let's see if we can get it going. Okay? Ooh-wee. And comes down the undersigned, and the court may not refuse an affidavit testimony. The hearing, insert the date, the judge, hallucinations, nonsensical, gobbledygook, such language exceeds the bounds of that judicial officer. The same judicial officer later disclaimed knowledge of the scheduled 220 hearing, proceeding set by her own order, despite the hearing being placed on the record. And wake up. We're going to take care of this. The way the court did things by scheduling the hearing at 2:20 was to waste the time of the petitioner. You see, the judge and the prosecuting attorney, opposing party, both get paid to be in court. The petitioner does not. The court is responsible for the time the petitioner stayed at the courthouse for greater than 6 hours that day, addressing the concerns of the court, which were invalid on its face. Period. The court is not permitted to waste the time of the public or of any party, and by scheduling a hearing and then claiming it didn't schedule the hearing, comma, and then making fun of the petitioner for having shown up to the hearing, meant that the court was doing this intentionally to show her prejudice and her disdain for the petitioner. And we do hereby ask for the recusal of the judge, and these are grounds for such recusal. Period. You are providing for this the case citations and incorporating a section solely on this issue alone, which will consist of at least 4 paragraphs showing how the court, by ordering the hearing, abused her discretion by not conducting the hearing at the scheduled time, and by having the party show up at the hearing and be prepared for the hearing and then claim it was never scheduled is false and misleading information on the public record. And then stating that it would be rescheduled for another day and making light of the fact that the individual had shown up also shows prejudicial conduct. Exclamation mark. This judge has been accused by the petitioner and or her family of the same type of conduct previously, so that there is a history of such conduct by this particular judicial officer and this court. Stop listening. Give us a second, y'all. Okay, there's no need for y'all to wait through everything, so I just had to make sure it did what it was supposed to do. And Civil Rights Act is appropriate with the district court, so that is the proper court to bring such a claim. Same judicial officer later disclaimed knowledge of the 220 hearing. Placing material false statements on the record constitutes fraud upon the court, and when knowingly done, that's what we're doing, because they're playing games, and so this is how you stop the gameplay. Okay, it's all a game to them, and when they are having you show up at hearings, y'all do need to create a fee schedule. That's what the 1099-Cs is for. Okay, now, Civil Rights Act secures to every person the right to give evidence and equal protection of laws, the right to give evidence and to equal protection of law. That right was violated when a judge adopts prejudicial language and refuses to recognize lawful filings by a petitioner without jurisdiction justification. The Supreme Court held in this case, this is a due process case. It's a well-known case. It's Hines versus Kerner. Okay, and it's pro se filings that will be liberally construed. It's a well-known case, and people use it all the time. Furthermore, any claim by the court that use of an AI-generated language or formatting tools invalidated filing wholly without merit and contrary to the historical practice since the 70s and early 80s, courts, attorneys, and clerks of staff have used word processing technology that incorporates predictive text grammar checking and automated formatting and machine-based case research tools. All such tools operate through algorithms, whether primitive or modern, and constitute artificial language modeling. Judges themselves rely on case management systems, legal research databases, and transcript processing software that all incorporate artificial intelligence functions, whether using Westlaw, LexisNexis, or internal court-based platforms. The judiciary employs computer-based intelligence daily. It is therefore disingenuous and discriminatory for any judge to object to a litigant's use of modern language processing tools when preparing filings. To do so while accepting AI assistance for judicial operations is hypocritical and prejudicial. Okay, that's what I was looking for. It actually gave me what I needed. That was for you guys. That was designed to help you understand what's going on in the court and why you're being denied. Now, they're not saying it out loud, but they're saying it. They know that all of you are using the so-called large language models. Well, this is how you kill that presumption, like I call myself the presumption killer. Every time you see me doing a video, that's all I'm doing is killing all of the stupid presumptions because they are stupid. Presumption of law is the most stupidest. I said stupidest piece of junk out there that's ever been invented by some stupid, ignorant attorney, lawyer, or Congress member and or judge. It was embedded in Article, pay attention, 3 of the Constitution. Well, not actually in the Article 3 of the Constitution, it was embedded in the comments during the debates. They actually spoke of presumption of law. There is no such thing as presumption of law, and Congress could not incorporate such an stupid principle, policy, or junk into the Constitution because the Constitution never gave them authorization to do so. It really is that simple. Look up presumption of law, understand presumption of law. Let's do that here. Give me a second. What is a presumption of law, and what makes a presumption of law legal? Now, you see I said what makes a presumption of law legal? Nothing makes a presumption of law legal. Watch this. Wake up. You are a liar. Nothing makes a presumption of law legal. You cannot make a rule, and a presumption of law is not a rule. It's a doctrine, and there is no such thing as a doctrine like presumption of law being legal because the courts must derive any and all conclusions based on facts. They cannot make a conclusion based on a presumption. Or did you not read the Constitution's due process requirement and equal protection of law requirement? Stop listening. The court of law may not substitute a presumption for a fact. It may not reach a conclusion of law absent factual predicate. Any so-called presumption of law that operates without evidence violate. Hold on. And that's where you are again stupid. If a presumption has evidence, then it's not a presumption. Therefore, a presumption of law is illegal because only evidence that is factual and based on actual evidence is lawful in the United States. There is no provision in law for a presumption standing as fact in the United States. The rule that a presumption must yield to facts is elementary. No, it's not that it must yield to facts, it's that a presumption is not fact. Pay attention, a presumption must yield to facts. This means a presumption is not fact. Give me a second, we need this. That's how I can tell you it's not law. The very fact that it says it must yield to facts means that a presumption is not in and of itself fact. And the courts cannot rely on a presumption, and a presumption can never be evidence because evidence must always be based on facts. Stop listening. You always hear the Army talking about facts on the ground. It can't be presumptive. You're absolutely correct. Both constitutional principle and lawful reasoning. A presumption by its very nature is not a fact. It is an assumption made without proof. The United States Constitution forbids the courts from reaching legal conclusions based on anything less than actual evidence. No person shall be deprived of life, liberty, or property without due process of law. The denial to any person within its jurisdiction of equal protection of law, 14th Amendment. Okay, then it says these clauses demand that all judicial determinations be grounded by provable fact, not conjecture, assumption, or legal fiction. But remember, the all caps name is a legal fiction, a presumption. As you correctly cited, the Supreme Court in this case said the rule is it must yield the fact. Well, if it has to yield the fact, see, a presumption must yield to fact. That means it's not a fact. Presumptions are not evidence. Presumptions are not facts. Presumptions cannot be the basis for a lawful judgment under constitutional standard. Any judicial order So, give me a second. We're going to do it this way. Create a universal petition that challenges presumption of law as a challenge to jurisdiction and demands that its use be strictly prohibited during the course of the matter, since this matter is a matter of due process of law, a matter of right, and a matter of accessing the court. And in order to access the court must always rely on factual evidence and not assumptions and or presumptions, as an assumption and or presumption are not fact. And because it's not fact, courts can only come to factual conclusions of law and not presumptive, non-conclusive law. Stop listening. And I promise y'all, that's the last one. That's the last one, because I's got to go. It keeps doing the bankruptcy petition. I told it to do another petition. Presumptions are inherently non-factual. They rise from assumptions rather than from verifiable evidence. Furthermore, a proceeding that permits or relies upon a presumption, assumption, or conclusion not rooted in factual record is inherently defective. You see, that's what the judge was doing when the judge, okay, I see what he did. He continued it. Okay, so he did do a different petition, but he didn't do a different petition. All right, that's it, y'all. I told you that was the last one. Gotta go.